Again, same terms and, actually, it just says, no contact with Andrew Hutchison or minor child MH, date of birth August 21st, 2022, but that no contact order can be modified at the request of Mr. Hutchison or in accordance with a DCF case plan. And then it would be as per the case plan. Is it $270 in that case?
Yes, Your Honor.
$270 in court costs, $100. Would that be a $50 cost of defense?
Oh, I apologize, it might be $50, I'm sorry. I think it probably is.
Their discretion. You know,
Yeah. The public defender fee.
Okay, so.
You have the full year, 2 years to pay.
Oh, okay. $100, well, she already paid the, after she had to pay more than one application.
no, they'll just be 50.
Okay, so the application fee is in the CF case, so this would be a $50.
Okay, thank you, Your Honor.
Sure, $50 cost of defense in the misdemeanor case. Now, also, this is not in here, but it's a standard term. There's a, I believe it's $55 a month cost of supervision that cannot be waived.
That's correct.
So just be aware of that.
I've provided the check-in
You
code
need-
for Ms. Dotson, so
Okay.
as soon as she gets out, just within 24 hours, scan
Yes,
that
you
code.
must scan that and check in within
Better to
24
scan
hours.
that code with your phone. You can call them if you have questions, but you're going to be checking in online.
Yes, and you have 30 days to appeal the order of the court. If you cannot afford a lawyer, one will be appointed for you. I left out a term, I don't see it printed on here, but you must take all your prescribed medication as prescribed. That's, that'll be a term of probation. So,
And no alcohol. And, oh,
Because it's
I was going to say
JCS.
no alcohol.
Because it's JCS, the standard term is no alcohol to excess. So we would request that it's no alcohol at all. And I was kind of batting it back and forth on whether or not the prescription condition like covers it. Because if the prescription says don't take with alcohol, that would
I
not
think
be
it would-
taking your prescription as prescribed.
We could add it to the plea agreement if the state would feel more comfortable, but I do believe that that's a term of probation anyway. The
Okay.
JCS is that you can't.
well, it may say not to excess, but in light of this situation, I would,
Yes,
I would
Your
say no alcohol. I wrote it on here. Do you want to make a copy of it or take a picture or anything?
No, that's okay, Your Honor. I'll write it on her copy.
Okay.
No
I
alcohol.
Take all medications as prescribed. Or I should say mental health medications.
Yeah, so just keep.
Take all mental health medications as prescribed and no alcohol.
Thank you, Judge.
Thank you. Ma'am, you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one. Thank you.
Robert Escolds is next.
All right.
All right.
I'll credit for time served?
Yes, of
Okay,
course.
okay.
Okay, he's just signed. He's signing it.
All right, is this Mr.
Is that test?
Esfold, 25, CF
Was
322?
that test? Oh, okay.
Sign the plea agreement.
Here's this.
Thank you.
Here you go.
And I'll have you sign this too. And I'll give you this copy. Great, thank you.
Does it say how many days? Or did they do that?
No, they do that at the
Okay,
jail,
I already have
yes.
them. Okay, cool.
Yes. Thank you so much.
Just okay. Might be late.
Yeah, that's all right.
Yeah.
And that's like done, right? I already signed all those papers.
Yeah.
All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down if you'll just state your name, please.
Robert Peter Esco III.
Thank you. You are here in case 25 CF 322 on one allegation that you violated your probation, and that's in accordance with the affidavit filed on September 17th, 2025. Have you had a chance to talk to your lawyer about that allegation you violated your probation?
Yes, Your Honor.
All right. Have you discussed the plea agreement with your lawyer?
Yes, Your Honor.
Did you read and sign the agreement?
Yes, Your Honor.
Is that your signature on the back page?
Yes, ma'am.
All right. Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
All right. You understand you're giving up your right to have a contested hearing, at which time the state would have to prove the allegation?
Yes, Your Honor.
All right. Has anybody promised you anything to make you enter an admission today?
No, ma'am.
All right. Has anyone threatened you or forced you to admit the violation today?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Are you admitting the violation of probation?
Yes, ma'am.
I find that your admission was freely and voluntarily entered, and in accordance with your agreement, I believe there's already been an adjudication of guilt. The court does find there's a violation of probation, and probation is revoked and terminated, and you are sentenced to 120 days in the Okaloosa County Jail with credit for time served. And in addition to any previously imposed fees and costs, there's a $150 cost of defense fee that includes the $50 application fee, and a $100 VOP cost of prosecution fee. You'll have 24 months after you get out to pay all of your outstanding costs and fees before they go to collections. And then once they go to collections, that's going to affect your driver's license. So if you need a payment plan, the clerk of court will work with you on that.
Okay, thank you.
All right, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one. Good luck, sir.
Okay, thank you. Thank you, Ruth.
See you later.
Frank, I have something. Sean Chaplin's next.
I was just answering a little last-minute question here with Mr. Chaplin. I'm going to have him sign the plea agreement
Okay, thank you.
right there. Perfect. Thanks. All right, Your Honor, if I could approach
Yes,
with the plea agreement.
sure. Is this Mr. Sean Chaplin?
Yes, ma'am.
All right, great, thank you.
And that is my client. I told just separately the name for him to find out. I told him to just be patient.
Thank you. And we're here in case 2020 CF 292 on allegations that you violated your probation. Let me just pull up your case. I fixed it on that one as well, don't worry. I'm sorry, this is not a VOP case. This is
It
an open
is.
case. So sorry,
No.
forget what I said about violating
No,
probation.
Your Honor, this is a,
Regular,
no, this is a
oh, it is.
VOP.
so sorry.
That's okay. He's had a couple violations.
Sorry, I was looking at the wrong thing. There's someone with a very similar last name as you, and I'd accidentally clicked on that. So sorry. You are here on a violation of probation, and I'm trying to find the affidavit. There it is. July 30th, 2025, and it has one allegation that you violated your probation in case 2020 CF 292. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
All right. Have you discussed this plea agreement with your lawyer?
I have.
Did you read and sign the agreement?
Yes, I have.
Is that your signature on the back page?
Yes, it is.
All right. Do you understand you're giving up your right to have an evidentiary hearing and make the state prove the allegation?
I understand.
Are you admitting the allegation that you violated your probation freely and voluntarily?
Yes.
Has anybody forced you or threatened you to admit it?
No.
Is anyone promising you anything other than what's showing on this agreement?
No.
Are you satisfied with your lawyer?
Yes, ma'am.
I have a score sheet. It shows 125.8 total sentence points, and that equates to a lowest permissible prison sentence of 73.35 months.
That is correct, Your Honor.
All right. Any objections to
No
the score
objections.
sheet? Okay. All right, sir, do you admit the allegation that you violated your probation that's in the affidavit of July 30th, 2025?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. And in accordance with your agreement, I believe there's already been an adjudication of guilt on the 3 charges.
Yes, Your Honor.
Yeah. Probation is revoked and terminated, and on each count, you are sentenced to the guideline sentence of 73.35 months in state prison concurrent, and you will get credit for all time served, and the state is also stipulating to credit for time served at Okaloosa County Jail and at Phoenix House, and the dates of Phoenix House are November 19th, 2024 through July 21st, 2025.
And Your Honor, if I may, I got those dates from probation, just to confirm that those were the dates he was at Phoenix House.
Okay.
I also inquired with Okaloosa County Jail about the time credit. Of course, they will do the final calculation just
Okay,
now that
yes.
he's been sentenced, but when I did check with them, he has 490 days credit at OCJ as well. I didn't put that number in there because I wanted to leave it up to OCJ.
Yes.
But I did confirm those numbers with probation and with Lieutenant Kaler at the jail.
Okay. And let's see, costs. I see on the plea agreement, $150 cost of defense, $100 cost of prosecution fee. That's in addition to any previously imposed fees, fines, or costs. Did I leave out anything?
No, Your Honor.
All right, so sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you, sir. Thank you.
This is your copy.
Next up is Eric Salazar.
And then, Mr. Medina, we have a case of yours on Zoom that we
Yes,
need to
Your Honor.
take after this case of them holding up the jail.
Good.
All right.
All right, Your Honor, this is Eric Salazar, 2019-2238. I'm having him sign the plea agreement that the state and the defense have reached.
All right.
Update. Okay. Your Honor, if I may approach.
Yes. Thank you. Thank you so much. All right, sir, I'm Judge Clark. If you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do." Thank you, sir. You can put your hand down. And can you state your name, please?
Eric Salazar.
Thank you. In case 2019 CF 2238, you're here on allegations that you violated your probation. There are 3 allegations in the amended affidavit that was filed on August 26, 2024. Have you had a chance to talk to your lawyer about those allegations and any possible defenses?
Yes.
Did you discuss this agreement with your lawyer?
Yes.
Did you read and sign the agreement?
Yes.
Is that your signature on the back page?
Yes.
Do you understand that you're giving up your right to have an evidentiary hearing and make the state prove the allegations?
Yes.
Has anybody promised you anything other than what's showing on this agreement?
No.
Is anybody threatening you to make you admit the allegations?
No.
Are you satisfied with the services of your lawyer?
Yes.
I have a score sheet. It shows 16 total sentence points. Any objections or corrections?
No, Your Honor.
Are you admitting the allegations that you violated your probation?
Yes.
I accept your admission. I find it was freely and voluntarily given in accordance with your agreement. The court finds that you did in fact violate your probation. It looks like there's already an adjudication of guilt on the underlying charges. And we're only dealing with count 1 at this point. The time has expired on count 2.
Correct.
So as to count 1, probation is revoked and terminated. Write that on here.
Oh, I apologize.
Oh, that's okay.
Thank you.
That's okay. And you are sentenced to 270 days in the Okaloosa County Jail with credit for time served. I also see there's a request for reimbursement from Okaloosa County Sheriff's Office on here, and that is, I'm waiting for it to load. It was filed on August 22nd. Oh, it's $904.80. It's from Wharton County Jail in Wharton, Texas.
Is it a transport cost?
Yes. Yes, 624 miles.
And is the state requesting that be added to the plea agreement?
I think they're entitled to it by law.
Okay. So does that, does that change the decision to enter a plea?
Yes, Your
Or
Honor. My
admission?
client does not wish to pay the cost of transport, so I need to speak with him and just state about that.
Okay,
We're,
then-
unaware of that.
Okay, then,
What, did Your Honor say it was in the court file?
yes, August 22nd, it's docket number 78. Oh, I do, here you go. Thank you. Well, I signed that, so just kind of scratch all over it, or scratch my, it's, all right, well, in light of that, I will
Okay.
allow Mr. Salazar to retract his admission.
Okay,
that he
I'll
just
speak
made.
with him. If maybe you could put him in the attorney-client room. Yeah, I'll speak with him about it, and we might bring him back out.
Okay,
If not, then I'll address it, and we can maybe continue it to the December date.
let me go ahead and do that now.
Okay.
And then if Mr. Salazar, he'll be here for a little
Yes,
while, so if you
yes.
decide to bring him back out, then we can do that.
Definitely.
So, but this way he doesn't have to come back out just to get a new court date.
you.
December 16th at 9.
Okay, thank you.
Thank you,
I'm
sir.
gonna come talk to you.
Okay, so Mr. Medina, we have the jail on Zoom. I'm going to bring him in. Thank you, everybody at the jail. I appreciate you very much being able to accommodate us on such short notice.
Your Honor.
And we're here on case 25 CF 2044, and that's Mr. Jonathan Boyd. And sir, are you Mr. Jonathan Boyd?
Yes, ma'am.
Thank you. I'm Judge Clark, and your attorney is here. There was a discrepancy with the docket. That's why you were not transported. So are you okay with proceeding with your hearing, even though you're on Zoom and we're here in the courtroom?
Yes, ma'am.
Okay. The alternative would be I can reschedule it if you,
Your Honor, we're fine with proceeding
okay.
in this manner.
So let me, if you'll just bear with me, Mr. Medina, let me get a piece of paper because I've run out of room to write things on my docket, so. And I need to read the motion. Okay, we're here on a motion to set bond that was filed on November 7th. And I'm reviewing that right now. And I need to review the first appearance paperwork. Bond was set by Judge Stone at first appearance on October 4th. Okay, I have reviewed the paperwork, and let me just check. I don't think the state has filed an information yet, or?
No, Your Honor, I just received this case. I think this was an arrest, I think 7 to 10 days ago, I believe. I think it's the beginning of November.
Okay.
So no, I have not filed an information yet, but the state will be.
Okay, it looks like the arraignment, oh no. There was a written plea of not guilty filed, so sorry, but I'm not seeing an information. So
Well, he had his plea day on November 13th.
Yeah.
But if there wasn't an information, we jumped the gun on the written plea of not guilty, but we didn't want him to have to
Right.
make the long trip in the car when he was going to be having a bond hearing 5 days later.
So, yeah, I think the
Meaning
state,
the bus.
the state still needs to file an information, and then you may have to refile the written plea of not
Yes,
guilty.
ma'am.
Okay. So the charges at this moment are,
The state will be filing as it's charged in the clerks, if that helps, Your Honor.
thank you, yes.
Nothing will be added or taken off.
1 count of cocaine trafficking, 28 grams or more, but less than 150 kilograms. Resisting, well, that's a first-degree felony. Then there's resisting an officer without violence. That's a first-degree misdemeanor. Possession of drug paraphernalia, also a first-degree misdemeanor. And tampering with or destroying evidence. Now, if I'm not mistaken, that's a third-degree felony, but.
That's correct, Your Honor.
Okay, thank you. So those are the charges, and bond was set by Judge Stone in the total amount.
I may have done the wrong math, because it looks like it was 350,000, not 300,000.
Correct, it looks like $350,000 to me. And,
Yes.
okay, I have reviewed the motion, and whenever you're ready, Mr. Medina.
Thank you, Your Honor. Could Mr. Boyd be sworn?
Yes. Mr. Boyd, will you please raise your right hand? Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down.
Mr. Boyd, can you hear me okay?
Yes, sir.
I don't know if you can see me, but this is your public defender, Steve Medina, right? We've met.
Yes, sir.
Okay. I want to go through some background about your family situation, living situation, and your medical conditions primarily. But before we get to that, the court has corrected me. The present bail is $350,000 cash and professional. Are you and your family able to make that amount of bail?
No, sir.
And I've talked to you and your family, and is it true that you and your family could come up with no more than a total of $50,000 cash or professional, which would be $5,000 to a bondsman?
Yes, sir.
Okay. Now let me ask you about, with whom do you live and where do you live normally?
With my aunt Alberta Simpkins, 26 West Alger Drive, Fort Walton Beach, Florida.
And just for the court's awareness, I think Ms. Simpkins is in the courtroom today. If you're Alberta Simpkins, would you raise your hand?
Okay, I
Thank
see a
you,
lady
Judge.
raising her hand.
Your Honor, excuse me, I'll just proceed. Mr. Boyd, how long have you lived in Okaloosa County, Florida?
That'll be probably 39 years.
And how old are you now?
50.
Okay. And I want to ask you about your medical condition. Are you on full disability?
Yes, sir.
And what are you on disability for?
My kidneys.
Okay.
I'm on dialysis.
Okay. So what is your kidney condition called? Can you tell us, the court, what it specifically is the issue with your kidneys?
Well, I have renal failure.
Okay. And do you have to get kidney dialysis?
Yes, sir.
Okay. And do you have any other serious medical issues other than the renal condition?
My left eye.
Okay.
I'm blind in my left eye.
Okay. And do you have a port in your chest? And if so, what is that for?
That's for my dialysis.
Okay. Do you have to go while you're in the jail, or if you're not in the jail, do you have to go 3 times a week for renal treatment, kidney dialysis in Fort Walton Beach, Florida?
Yes, sir.
Okay. And you would normally be making a relatively short trip from 26 West Audrey Street, Fort Walton Beach, 3 times a week. Is that correct?
Yes, sir.
But right now, you have to do 3 times a week, and the jail has to provide that transport to get the dialysis to Fort Walton Beach. Is that correct?
Yes, sir.
Okay. And the person that normally drives you, I think is in the court. I'm going to have her testify in a minute, but that's your sister, Miss Angel Rogers. Is that correct?
Yes, sir.
Okay. Well, let me ask you a little bit more about your medical condition. Does your medical condition require any special dietary items, or are you otherwise required to have special dietary items that are not readily available at the jail?
Dietary items that's not here at the jail.
Okay, and why do you have to have these special dietary items, if you know?
To actually flush my system.
And can you describe what the doctors have told you needed to be eating that you don't get at the jail?
Well, a lot of baked chicken, baked fish, a lot of greens,
Okay. Right.
and fruit.
Okay. If the court were willing to reduce your bond, would you be willing to be on a GPS monitor at $1 a day to make sure the pretrial services knew where you were?
Yes, sir.
And would you be willing to be restricted to your residence at 26 West Audrey Street, Fort Walton Beach, while your case was pending, except for approved medical appointments?
Yes, sir.
Okay. Without talking about the facts of your case, is there anything more, in your own words, you wanted to tell the court about your medical condition and why you're seeking a motion for a bond reduction? If there is anything else, if not, that's fine. But I just wanted to make sure I didn't leave anything out, because this is your chance to try to get a bond reduction.
Well, you pretty much got it all, sir.
Okay. Your Honor, I don't have any other questions. I will be calling Angel Rogers after cross-examination.
All right. Cross by the state?
Mr. Boyd, you've been convicted of sale, manufacture, deliver of controlled substances in the past, haven't you?
Objection, this is beyond the scope. I haven't asked him anything about his prior convictions. I've only been asking him about his medical condition and his ability to post bond. This is beyond the scope.
And it's relevant for bond purposes.
It is beyond the scope. He has a Fifth Amendment right to not discuss anything that might come out in trial, and priors is certainly a potential trial issue.
I will sustain the objection without prejudice to the state to advise the court of priors.
Perfect, Your Honor. I have no further questions then.
Okay, thank you.
No redirect, Your Honor.
Okay, thank you, sir. And Mr. Medina, call your next witness.
Mr. Boyd, may I just ask him, are you okay standing? Are you normally in a wheelchair, or are you normally just walking around?
I'm sitting here right now.
Okay, you're sitting, okay, all right.
Okay.
Your Honor, can he sit down
Of
while
course he
continue?
can.
Okay,
Yes,
thank you.
sure. Okay,
Your Honor, could I call very briefly his sister, Angel Rogers, who's present in the courtroom?
of course.
She'll
She can-
come forward
come on up
and
to
just
the-
testify here, if that's okay.
Yes.
This will be very brief, Your Honor.
All right, and ma'am, if you'll just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. And Mr. Medina, whenever you're ready.
Thank you, ma'am. Thank you, Your Honor. What is your full name now?
Angel Shashika Rogers,
And what is your address?
91 Ball Lane, Bruton, Alabama, 36426.
Okay, and the female that you're sitting next to, is that?
That's both of our aunt,
Okay, and her name is what?
Alberta
Okay,
Simpkins.
thank you. And what type of assistance do you normally play in the life of your brother, Jonathan Boyd?
That's my best friend. But,
As far as his medical conditions?
but
in particular?
we spend a lot of time together. We eat together. I take him to his doctor's appointments, and I also take him to dialysis whenever I'm needed.
Okay. How does he normally get to dialysis if you don't provide the transportation?
Well, he'll take a cab.
Okay. But that's really expensive.
Yes, I provide his as much as I can.
Okay. And do you have to take off work to do that?
No, my schedule is kind of flexible. I'm a housekeeper and I work here in Florida, so I'm here most of the time.
Okay. So you just try to arrange it on the way to your work schedule?
Yeah, I kind of work my schedule the best I can around the things that he needs me to do.
And a lot of your work is in South Okaloosa County, is that right?
It's in Destin and Sandestin.
Okay, thank you. All right. Without talking about the facts of his case, is there anything else you wanted the court to know about or consider in reducing bond?
I'm just very worried about his conditions at the jail. He's fell out with his sugar dropping.
Objection, lack of knowledge.
Sustained.
Well,
You don't need to talk about his medical conditions as a doctor, but.
well, I just know he fell out, so I was just concerned. But that's a concern of mine, is his care and his health while he's incarcerated. So that's why we want to try to get him home, so we can make sure he's eating the right things and he's going to the doctor as needed.
Okay, and is this a, I'm not trying to be rude, but is this in some sort of contrived way of getting him home? Or does he really have these serious concerns?
Yes,
that
all
you-
this
that
is
you
documented.
share?
All this is documented from his dialysis doctor I've talked to his caregivers.
Okay. All right, thank you. Nothing further, I'll let Cross.
Any cross?
I have no questions.
Okay, thank you, ma'am. You can go back to your seat. And Mr. Medina, any other witnesses?
No, Your Honor, thank you.
Okay. So, well, actually, I do have some questions. You're not calling Ms. Simpkins?
I could, but I wasn't planning on it.
Okay.
I think it was covered that he lives with her adequately, but if we need to have her up, if the court has any questions,
I do.
Are you able to walk forward, Alberta Simpkins, Ms. Simpkins? Do you mind answering a couple questions? Excuse me. Okay, so come on forward if you don't mind. Right here, and don't be nervous, okay? Thank you.
Thank you, ma'am. If you'll just raise your,
I didn't.
if you'll just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, ma'am. You can put your hand down if you'll just tell us your name.
Alberta Simpkins.
Thank you. Mr. Medina, I know you weren't going to inquire. I just wanted to make sure that Ms. Simpkins is okay with Mr. Boyd returning to her home, and would it be a hardship if he were required to be on house arrest sanctions there if he were to make bond?
And so would you answer the court's question and make sure you understand what the court's asking?
Are you okay with him returning to your home?
I'm okay.
Okay, and if he did make bond, if he were ordered to remain in the house and not leave unless he was going to court or to a medical appointment, dialysis or doctor's appointment, are you okay with that? With
And he's a grown
him
man,
basically
so
being
he
there
should be able-
24/7?
yes, he should be able to, yeah. Yes, I'm
Okay. Ma'am, if he were violating the conditions of his release, would you be agreeable to reporting that?
Yes.
Okay. All right. I can't think of anything else I want to ask Ms. Gaynor.
I just wanted to confirm, is your address also in Bruton or is that in Florida?
Audrey, 26 West Audrey Drive.
That's in Fort Walton? Okay. That's the only confusion I had. I didn't know if you guys were sure together.
And Mr. Medina, if there's anything you wish to follow up on, go ahead.
Thank you, Ms. Simpkins.
Thank you, ma'am.
Put
That's,
you under the
that's all I needed to know.
Hot seat here.
Thank you.
Thank you. Nothing further, Your Honor,
Okay, and
unless the court has other questions.
no, I don't. So I'm going to let the, okay, so what are you asking for? And then I'll let the state respond.
We're asking for a, not for signature bonds, but he already has an ROR on the paraphernalia charge. We're asking for the court in any way, any combination the court sees fit with respect to the cocaine trafficking charge, the resisting officer without violence, and the evidence destruction, for the court to have a total of not more than $50,000 cash or professional instead of the current $350,000 cash or professional, so that that can be something that he's financially capable of furnishing. We're asking for the court to add additional restrictions as the court sees fit. We have suggested that the court might wish to consider, among other things, as the court saw fit, placing him on pretrial services with such visits as the court deems necessary in person and by phone, GPS at $1 a day, and restrict him to his residence at 26 West Audrey Street, Fort Walton Beach, except for approved medical appointments and, as the court pointed out, court appointments.
All right.
And of course, if he did have to report in person to pretrial services, that would be another court-related appointment.
All right. And what is the state's position?
Your Honor, the state's position is that the bond should remain the same. Judge Stone got it right the first time around, especially when you look at the first appearance sheet. Specifically, 1, 2, 3, page 4, Your Honor, shows that his risk assessment score is 23, putting him into a high category of risk assessment. On that paperwork, there's 2 failures to appear, 2 violent felonies, 5 felony possession of controlled substances that he's been convicted of, 2 possessions with intent to sale or distribute cases, violent misdemeanors of 4, other misdemeanors of 10, and other felonies listed at 11. Specifically, Your Honor, in 4695 CF 1420, he was charged and convicted of sale, manufacture, deliver of drugs. 4695 CF 77, again convicted of sale, manufacture, deliver of cocaine in that case. 4693 CF 1533, convicted of sale, manufacture, deliver of controlled substance as well. Just as recent as 4617, so 2017 CF 2422, he was convicted of possession of controlled substance again, and possession of marijuana less than 20 grams. Your Honor, I want to look at the facts of the case that's in front of us, the PC. The PC here, immediately, basically, Mr. Boyd starts running from law enforcement on foot. The deputies run after him, attempt to tase him, go as far as pulling their department-issued taser out. The taser was unsuccessful. Thankfully, the defendant tripped and fell. The deputies were able to catch up to him at that point. However, though, when the defendant did trip and fall, the baggies of the suspected cocaine, the defendant grabbed out and was trying to tear open the bags and spill them out onto the ground. There was actually some that did make it onto the ground due to him ripping the bags open. That is where the tampering and destruction charge comes from. Your Honor, he ran. I understand this individual may have some medical issues, but he's well enough to run from the cops. He's well enough to tamper and destroy evidence. He's healthy enough to buy 45 grams, which is what's suspected of cocaine in this case. That is in the PC. It's about 45 grams. He's honestly well enough to be able to afford to buy 45 grams of cocaine. Your Honor, just because the bond is set at $350,000 doesn't mean it's an unreasonable bond just because the defendant can't pay it. As far as the medical issues go, Your Honor, I think this court and the state and honestly the PD's office is, we've had several cases where Lieutenant Cantler, Major McDaniel, somebody from the jail will contact us if they can't provide adequate care or if there's some issues with some health-related issues with an inmate. I've not been contacted once by the jail regarding their inability to provide the care for Mr. Boyd. In fact, as he stated today, that they're taking him to his dialysis appointments, and he's still receiving that care. I have not been contacted in any way to amend the bond per the jail's request or anything regarding that. Your Honor, I think, regarding just the probable cause in this case, the first appearance sheet listing out his criminal history as well as, particularly the drug charges that he's had in the past, and the fact that, this bond was set by Judge Stone at that first appearance. I think he got it right as far as the amount goes, Your Honor. This is a trafficking case. Has a mandatory minimum attached to it. And I don't believe that the medical conditions that are cited in this motion from defense, they're all being cared for adequately by the jail.
Please do not talk unless you're requested to answer a question, okay? Thank you. Sorry, Your Honor.
No problem.
May I argue, Your Honor?
Yes,
Okay.
yes, go ahead.
Your Honor, I wanted to point out, as the defendant pointed out, he is blind in his left eye. We do not have the state's video evidence yet or the state's discovery in general. All we have is this probable cause narrative. There was evidently a pedestrian stop or attempted pedestrian stop, and with the visual impairment, we do not know what this individual was able to see. So I'm simply pointing out is that we need to see the video, and basically if, for instance, a gun was drawn and bright lights were seen by a visually impaired person at a pedestrian intersection, it's really conjecture to know the person's state of mind in fleeing. It might have been a perfectly rational act to flee, but it's all really not going to be germane to the practical situation of a severely physically impaired person. Granted, the allegation is that he did flee on foot. I'm not going to deny that statement that he fled on foot. But he is visually impaired as well as severely impaired with dialysis. And the GPS at $1 a day would find out very quickly if he left where he was supposed to be. The restriction to his residence could be augmented by the aunt has already said she would be happy to report if he's not abiding by the conditions. So I think that there are open questions about what the actual facts are perceived from a visually impaired person, and we can deal with the pragmatics. In essence, should not be holding him simply for financial reasons when there is still would be a significant cash or professional bond of $50,000. Thank you.
Thank you. I looked up the statute, and of course, attorneys can please correct me if I'm wrong. It looks like it's a 3-year minimum mandatory for that weight if Mr. Boyd were to be convicted of the trafficking charge. But again, I defer to the attorneys to correct me if I've got the wrong statute.
That is correct, Your Honor. Okay.
So if you'll just bear with me for a few minutes, I'm writing. I have a paper order and I'm filling it out, and then I'll announce the ruling. All right, so the motion for bond reduction, I listened to the evidence. I considered the witnesses and the defendant's prior record, including the prior convictions and the prior failures to appear. I also considered the testimony regarding the defendant's medical conditions. And the court is granting the motion as follows. As to the trafficking in cocaine charge, which is a first-degree felony, the court is reducing bond to $100,000 cash or professional. It's currently set at $250,000. I've reduced it to $100,000. The resisting an officer without violence is currently set at $50,000 cash or professional. I've reduced that charge to $1,000 cash or professional. The paraphernalia charge was already set at an ROR bond. I'm leaving that alone. It'll remain ROR. The tampering with evidence or destroying evidence, that's a third-degree felony. The court is setting bond or reducing bond from $50,000 to $5,000 cash or professional. The following additional terms and conditions will apply. Pretrial services to monitor must check in weekly in person. A GPS monitor must be attached prior to release at a cost of $1 per day. Sir, you must remain confined to your approved residence at all times unless you are going to a medical appointment, court, your attorney's office, or pretrial services. Otherwise, you have to get permission in advance from pretrial services before you leave your home. And if you violate any of these terms or conditions, then your bond would be revoked and you would be returned to jail. So, did I leave out any terms or conditions or things I need to cover from the state's point of view?
No drugs or alcohol?
Oh, yeah, well, that's a standard, goes without saying, it is a standard term of pretrial services, but sir, you can't have any drugs without a prescription, and I don't know if there's I'm not going to mention anything about alcohol. Whatever the standard condition of pretrial services regarding alcohol is in effect, but I would suspect with Mr. Boyd's medical conditions, alcohol is probably not something that would be a good thing. But Mr. Medina, did I leave out anything that I need to cover?
No, Your Honor.
Okay.
I just want to confirm the next court date because we have this uncertainty about the information, I think, so we need to maybe put him back on
It'll be filed by the end of the day, all right?
Okay.
So we can probably just leave him on for 12/10.
He said, sir, I hate to talk about you like you're not even there. Your next pretrial conference is right now, it's February 9th. Do you want to keep that day, Mr. Medina, or do you want to move Mr. Boyd up to December?
I'd rather have it be December 10.
Sure.
Even if, I can always waive his appearance, but
Okay.
I think it's, we're not going to be having a trial this cycle. We haven't begun, the state hasn't had an opportunity to share its evidence and so forth, but I don't think it would be a bad idea.
Okay, 8th or 10th?
I think let's leave him on the 10th, and if he can't.
Well, he can show up on the 10th. If he bonds out, he can still come on the 10th.
Okay, so we'll move into the 8th.
Oh, the 8th, okay, fine. December 8th at 9 o'clock for pretrial conference.
Thank you, Your Honor.
Sure. So I've done a written order, and I'm going to hand that to Madam Clerk right now. Thank you. All right. Thank you very much, Mr. Boyd. Your court date is December the 8th at 9 o'clock. All right?
Yes, ma'am.
Thank you. And thank you to everyone at the jail. Very much appreciate you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. All right.
Your Honor, I think we're
Thank you.
recalling
Thank you.
Lachey Cooper, 23 CF 157.
Okay.
Yeah. Okay. So I just need to have you sign the plea agreement, okay? Okay. So it's 6 months, 180 days. Okay. Right there.
All right, Ms. Cooper is present again, and this is case 23 CF 1557.
Oh, yes.
Yep, I gotta put that. Yes, Your Honor, this is Ms. Cooper. The state and the defense have reached an agreement.
All right.
I just need to, there we go. Okay. If I may approach.
Yes.
Thank you. I apologize for the
Oh, that's fine.
edit there.
Thank you.
Sorry.
Oops, no problem. Thank you.
Not even breathing.
All right, and let me just fill out the paperwork.
And Your Honor, I neglected to put that this is a revoke and terminate supervision.
I'll look at it.
That's kind of the most important part. This is on the recommendation of probation. That's your version. Your copy.
All right, ma'am. Second. If you'll just raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, ma'am. You can put your hand down if you'll just tell me your name, please.
Lachey Monique Cooper.
Thank you, Ms. Cooper. You're here in 23 CF 1557. There are 9 allegations that you violated your probation. That's in an affidavit that was filed. It's an amended affidavit filed on October 28th, 2025. Have you had a chance to talk to your lawyer about those allegations that you violated your probation and any possible defenses?
I have spoke with my attorney.
All right. And have you discussed this agreement with your lawyer?
Yes, I have.
Did you read and sign the agreement?
Yes, I have.
Is that your signature on the back page?
Yes.
Do you understand the rights that you give up when you enter a plea or an admission?
Yes, ma'am.
Do you understand that you're giving up your right to have an evidentiary hearing and make the state prove the allegations?
Yes, ma'am.
Is anybody forcing you or threatening you to admit the violations?
No, ma'am.
Has anybody promised you anything other than what's showing on this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
I have a score sheet that shows 42 total sentence points. Any objections?
No, Your Honor.
Ma'am, are you admitting all 9 violations of the amended affidavit?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. It looks like there was already an adjudication of guilt on the underlying charges. The court does find that Ms. Cooper has violated her probation as alleged in the amended affidavit that I just mentioned. In accordance with the agreement, probation is revoked and terminated on both counts. And on both counts, or on each count, I should say, Ms. Cooper is sentenced to 180 days in the Okaloosa County Jail concurrent with credit for time served, whatever that turns out to be. And the additional costs and fees, this is in addition to anything previously assessed, $150 cost of defense, that includes the application fee, $100 cost of prosecution. Did I cover everything?
Yes, Your Honor.
Okay. Ma'am, you have 30 days to appeal the order of the court, and if you cannot afford a lawyer, I'll appoint one for you. Good luck to you, ma'am. Thank you.
Thanks.
Oh,
Thank you
Mr.
so much.
Doobie.
Okay, thank you.
Any outstanding financials, how long?
Oh, that's a good point.
If we could give her 24 months?
What is it? How much?
How long to pay?
Oh, okay.
24, sorry?
If we could give her 24 months, she's been in the jail for a little while.
24 months to pay all outstanding financials
Thank you.
before they go to collections.
Okay, thanks.
Thank you.
Thank you.
Salazar, Eric.
This thing too.
I think they're bringing out Mr. Salazar now.
Okay.
Sorry.
One more time.
Yeah, that's true.
All right, this is Mr. Eric Salazar recalled, and this is case 2019 CF 2238.
Just very briefly, Mr. Salazar, as we know, was transported from Texas. He turned himself in on this VOP warrant in February, and I'm just trying to get confirmation from Lieutenant Cantler at the jail that he was held since February. I don't have access, he wasn't transported here until August, but he received a bond in his Texas case, but was held anyway, only on the Okaloosa County hold. So theoretically, he should have credit essentially from February. I just need confirmation from Lieutenant Cantler, who I believe would have access to that information.
Okay.
I don't have access to it. So if we can continue the case, just for me to get confirmation of that, because then we would be able to include that in the plea agreement that he would be getting credit for that time.
Yes, we've already actually set the case for December 16th.
Right, so we can, I will reschedule it for an earlier date if we, as soon as I get that information, then I'll, of course, my office will contact your Honor's office for an early plea. But for
Okay.
now, we can leave it on the December 16th date.
Sure. Okay. Thank you. See you on December
Thank you.
16th, if
Thanks,
not
Mr.
before.
Salazar.
Thanks,
Thank
Andrew
you.
Banks is up next. And that's what
And
Mr.
then, Your
Medina.
Honor, my only case I think left is Mr. Freeland on Zoom, whenever we get to it.
Okay.
Steve Medina. Steve Medina was Xavier J. Banks, 25 CF 1134.
Yes.
At this time, Mr. Banks would respectfully deny the VOP. I would ask the court to please consider a December VOP without subpoenas continuance date. He has an offer from the state, and we need to discuss it and figure out where to go from here.
Okay. And we're here on the amended affidavit that was filed on October 31st, 2025. It has 6 allegations, and I will continue the case to December 16th at 9 o'clock.
In Your Honor, he also, I just note, as the court is aware, he has a misdemeanor charge, and this will also give him a little bit more opportunity to interface with the misdemeanor lawyer on that case.
That sounds,
That's part of the underlying basis.
yes, thank you.
Right this way, sir.
I'm sorry, the court say 12/14?
16th.
12/16, thank you.
Yes, December 16th at 9 o'clock.
Reginald L. Latham.
Reginald L. Defendant, Grossman, 23 CF 2582. Your Honor, I'm asking to continue him to December 16, have a denial entered. He has two cases pending in misdemeanor court, and that's somewhat up in the air. It appears that he pro se pled one of them out. And that's the subject of discussion I'm trying to understand, because that wouldn't normally be something that the public defender's office would be promoting. And so we're kind of looking into things on that and the other misdemeanor case. We would ask to continue to December 16th.
So there are three case numbers, 23 CF 2580, 23 CF 2581, and 23 CF 2582. And Ms. Gaynor, did you wish to say something?
Yes, Your Honor, he has already pled a 25 MM 2077. That was one of the bases for the VOPs, as well as a new law violation that he has pled to. He's on his probation includes a 10-year suspended sentence. State's ready to set this for a VOP hearing.
Okay. So
What I was alluding to, Judge, and the court, of course, if the state wants to set it for VOP evidentiary, we have no basis to object. I did want the court to anticipate is that my colleague in misdemeanor court, in county court, will be probably filing one or more motions. It would be inefficient for me to duplicate the wheel on those same motions, so it may have some benefit to see how that fleshes out. He's got a 10-year suspended sentence that he's in jail. We're not at this time trying to get him out. There's a recent acceptance at Phoenix House that he proactively sought. I was going to be seeking a Phoenix House. The charges, well, anyway, I don't need to over-argue this. We can set it for VOP evidentiary if the state wants.
Just, there's two misdemeanor cases. I know the one, I think is there's motions going to be filed in that one. And the state's thing is he's already pled to one of them, so.
Well, I think basically the situation is that, and I'm not privy to things since I've been in court this morning, but I know as of early this morning, there was possible discussion of seeking a withdrawal of that plea in one of those cases.
okay. So as to the three cases in our court, which I mentioned a minute ago, the case numbers, does the state, I actually have some time before the next regular VOP court date if you wish. I don't know how soon you're looking.
I can get ready quick, Your Honor, for it. I just need at least 5 days to get subpoenas out, but anything after that, I can get prepared for that pretty quickly.
I cannot be prepared to file motions and get them timed in an orderly manner, which really would need to be heard pretty much as a part A of a VOP evidentiary, is we need to deal with possible motions. There are some motions that, for instance, if one of the motions is to withdraw a plea that is purely in the jurisdiction of the county court. So I do not know how that's all going to sort out, so I would not, I respectfully object to setting something super early.
Okay.
Maybe by January we'll know what the motions are, if there are going to be any, and know what they are, but I'm not in the lead on that. So.
Okay.
And I don't know, I can't remember at the top of my head the exact days that is allowed to withdraw a plea, but just for everyone's knowledge, he pled July 1st, 2025 to that, so I don't know if that's within the
There are potential issues of whether he had the opportunity for counsel and so forth, but, you know.
Well, that will be sorted out in county court. In that case, I'm not assigned to that case, so I'm not going to wade into it, so.
Yes, sir.
All right. So, I was going to suggest, well, I mean, I have availability on December 4th, but Mr. Medina, I hear that you're objecting because there are things you need to do.
Well, it is coming up on holidays, so I really just think that's just too quick. I can't, because it's not only presuming what I could do, but what my colleague can do, Mr. Silva, so he needs to sort these things out. We have to discuss it with our supervisor and so forth. And I would note, I don't know for sure that the public defender will be staying on the case. That may be an issue too. So we have to flesh out a bunch of issues with our supervisor.
Okay. Well, what I'll do is, I'm going to go ahead and set December 16th, which is the normal just VOP docket day. And I will ask y'all if you wish to reach out to Amanda. I don't know how long you would need for the evidentiary hearing.
The state would only need 30 minutes max with our witnesses, a witness.
Oh, okay.
Both of the misdemeanor charges aren't anything too complicated, Your Honor.
Okay.
I just respectfully, I know a little bit about that misdemeanor loitering and prowling, and I realize he apparently pled that. But if that were reopened, I've had motions to suppress on similar issues relating to the mean high water line and so forth. So those lasted an hour or more, so.
Well, I will set the case for December 16th at 9, and y'all would need to reach out to Amanda or perhaps the clerk's office. I think that we're changing things up a little bit on scheduling. So if you want to schedule that hearing, then if it's not already scheduled or on the books for some date, when December 16th rolls around, we can revisit it then.
And I will also tell the court, Ms. Gainer, that I'm going to be in good faith trying to find out where he's going to stand on motions and so forth. So if I find out we don't have some motions and can just proceed to a relatively quick VOP evidentiary, then we can let your assistant know, and I'm not trying to drag it out.
Okay.
He does already have the Phoenix House acceptance, so in the event that, and the court is, even if he's found willfully and substantially in violation, still has discretion. And so with basically fairly minor charges, there's always the possibility of a plea to the bench.
All right. So, well, we'll see where we are on December 16th, but y'all can, if you wish to, if the state wants to schedule that hearing, just reach out to Amanda or the clerk to schedule it.
Thank you, Judge.
Sure. December 16th, sir, at 9 o'clock is your next court date. Okay?
Hiding room is up next.
Thank you.
Come on, Mr. Bethune.
Thank you.
The room.
Your Honor, Steve Medina with Ty and G Broom.
Okay.
Mr. Broom has a VOP case before the court, 24 CF 2425. We are going to do an agreement that resolves his misdemeanor cases too. And I had that information that it was only one misdemeanor case, but there's a 25 CT 2019 new law case, which is a reckless driving, second degree misdemeanor, I believe. And then there's also 25 MM 2571. I had bad information that it had been closed, resolved, but it has not been resolved. And so we are now going to be resolving it as part of this agreement. And
Okay.
I just need to make sure he sees this new language. It just takes one moment.
All right. So if you need more than a minute or so, I can take Ms. Farkas's client who is on Zoom, who's been sitting on Zoom for at least an hour.
And that's fine, and Mr. Broom, if whatever's, the bailiff says, but I just need to show him the new language, it'll take a minute, but we can wait, we're at the court's discretion.
You're ready now?
Yes, I am ready.
Okay, let me bring in Mr. Freeland and let's take care of that. He's on Zoom. And he's trying to join, he was in the waiting room, he's trying to, here he is, okay. All right, Mr. Freeland, can you hear me? Mr. Freeland, you're on mute.
Let me see, I'll take it off of mute.
Wonderful,
got
thank
it.
you,
Hey,
sir.
Mr. Freeland.
And we're here in case 24 CF.
You can hear me?
Yes, yes, we can.
Okay, good.
Yes.
Thank you.
24 CF 1122, 24 CF 1801, 24 CF 1802, and 24 CF 2621. And Mr. Freeland is present on Zoom.
Yes,
All
and
right.
I'm confirming that that is in fact Mr. Freeland.
Okay,
The state and the defense have reached an agreement, a global agreement that covers all 4 cases. Excuse me, I emailed the plea agreement to Mr. Freeland. He printed it out, signed it, and sent it back to me, and we have discussed it at length. So I appreciate Your Honor allowing him to enter this plea. This is very unusual for the court, so I very much appreciate it. He lives in Orlando, and his health does not allow him to travel very easily.
okay,
So that is why we requested that he be able to enter the plea this way.
okay.
If I may approach with
Yes.
the agreement.
Yes, thank you. Thank you so much. Thank you.
This will be a slight downward departure based off the necessity for restitution.
Okay,
And Your Honor, we would be happy to clarify the wording in the plea agreement about the restitution, if need be.
so the basis for the downward departure, I'm checking the box that says the need for payment of restitution to the victim outweighs the need for a prison sentence.
Yes, Your Honor.
Thank you.
And I'm also going to provide a copy to probation.
All right.
You might be nervous there.
So I have a question whenever you get a chance.
Yes, Your Honor.
On the public defender fees on case 1801, 1802.
Oh, yes.
Is it
Sorry.
100 instead of 150?
It should be 100,
Okay.
yes.
Thank you.
Thank you.
And let me just check on the costs.
1922 would be a misdemeanor and theft. Which is the other cases would be as charged. Thank you.
All right, Mr. Freeland, if you will please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your
Your
hand
Honor,
down.
I'm so
Yes.
sorry to interrupt. Was just speaking with probation about this case, and they wanted to confer with the state really briefly about a couple of the terms, just given that Mr. Freeland is in Orlando. So if we could just wait, just to make sure that everything, we want to make sure that everything is, whatever is easiest for probation. So just before he enters the plea. Hold on one second, Mr. Freeland.
Okay.
Okay.
I apologize, Your Honor. There's a lot of moving parts in all these cases, and with probation being in a different county.
Sure. And
Yes, Your Honor.
how's he going to check in?
Yes, so that's what we were just discussing.
Okay.
So probation was requesting it to be mail-in, which the state doesn't have an objection for mail-in reporting, because the main purpose of this probation period is restitution. So long as he makes the restitution payments, mails in, I think we're good.
When you say mail-in, is that literally mail? Or is that like shorthand for phone or Zoom or something?
Your Honor, it would be literal mail in, so he would either mail in through the postal service and or email a monthly written report in each month, and that would be his check-in with the office.
And Your Honor, I email with Mr. Freeland very regularly, so
Okay.
I'm very confident that he would be able to do that.
Okay, and I didn't see a minimum monthly payment on any of this restitution.
So that is partially because, Your Honor, I had originally requested that the state reserve restitution, and we essentially confirmed the amount. The property in question, it's my understanding that a large majority of it is completely untouched, like not out of packaging, et cetera. So it's very possible that the businesses will be able to retain the property from the sheriff's office, and therefore the amount of restitution will actually decrease, the amount of restitution owed. So the wording that we landed on is that the businesses will pick up their property from the sheriff's office and then let probation know, what the restitution actually is if it changes, which we are expecting that it will, because the property is the same as it was before.
Well, but that was in 2024, right? So,
Yes, which was exactly what the state attorney said when we were discussing the restitution issue. So of course, there's a possibility that the restitution amounts will remain as they are, but it's our understanding that because everything remains in its original packaging, et cetera, that the restitution amounts might decrease.
All right. Well, how is that going to be determined? I mean, I'm wondering, so let's say, I'm just...
Your Honor, I would maybe suggest that we set a status date on the amount of restitution. I'm not sure if that's overly complicated to set a status date on the amount of restitution in January or something like that.
He's being supervised, so I don't see it
that's true.
necessary for a status. It's either, what's going to happen is that because the property is evidence currently,
It'll be released.
it will be released. I'll tell the businesses that they can go pick up their property, and then from there, they will determine whether or not they have the full value of the property. I don't want to get into too much economics, but there's a time value of money,
Of course.
right? But
Well,
however,
Let me just
something is better than nothing.
say that, I mean, I see Best Buy is on here, I'm just thinking aloud, I have no idea what the items are. But let's say a computer in 2024 might have been worth X amount of dollars, but by the time Best Buy gets it back now,
Yes,
or
Your Honor.
whenever that is, I mean, it's not going to be worth what it might have been worth in 2024.
Yes, Your Honor,
So
so
I'm just wondering about
my
that.
only other suggestion was that that the state attorney reserve on restitution, allow the businesses to recoup the property and assess the value, and then we have a restitution hearing on the value. The state attorney requested that the restitution amounts be included in the plea agreement, essentially to ensure that Mr. Freeland is on the hook for those values in case the businesses can't recuperate the costs. So that's why we phrased it in this manner, just because of the amounts of money.
Okay.
I'm sorry.
Go ahead.
So, when we have theft cases from retail establishments, their value is the cost of the product at the time it was stolen. That's every single time that I get restitution forms and receipts and stuff like that. That's what their request is. The state's concerned with time value of money. It appears that never comes up in restitution with the retail businesses. It might come up with private individuals more so. Because they
Understood.
have other mechanisms of recouping their losses as well.
Okay. So I see that the cost of supervision is waived on 4 cases. Now, that means the taxpayers are going to have to carry that burden on 4 cases. So I'm not willing to accept a waiver of cost of supervision on 4 cases unless there's a substantial restitution payment made in each case that month. So, I mean, I just...
Your Honor, I included that just because the purpose of the plea agreement, really, obviously,
Yeah,
the state has many purposes, but the main purpose, of course, is to recuperate the cost
right.
of restitution, and so wanted any income that Mr. Freeland has to go to the restitution costs.
Yes. So, well, he wouldn't, I mean, let me ask probation this. I mean, if it's 4 cases, he'd only pay 1 cost of supervision, not 4 different ones, right, every month?
Correct, Your Honor. If
Okay.
I'm supervision in the state of Florida, it's just one
Okay.
set cost of supervision.
All right, so it's not 4 times $40, it's just
I understand, Your Honor.
$40 per month?
Yes.
Well, I mean, as long as he pays more than that in restitution per month, then the cost of supervision will be waived. But if
Yes.
there's no restitution payment made, then
Well,
there's
and
no
then he would
excuse.
be in violation of probation at that point anyway. I'm sure probation will inform us if that's
Well,
the case.
it doesn't have a monthly payment for restitution, so I don't think there would, But I'm just saying that there's no issue waiving cost of supervision as long as at least that much or more is paid towards restitution
Yes, Your
per
Honor.
month. Sir, do you understand that?
Yes, Your Honor, I do, and I will be paying that restitution off as soon as possible,
Okay.
of course.
Okay. So I'm writing on here off to the side. And I don't know, Ms. Farkas, if that changes your client's decision to accept the plea, because, I mean, I'm not willing to accept a blanket waiver of cost of
I
supervision.
understand, Your Honor. And I don't believe that changes his opinion.
No,
or his decision.
no, it doesn't, Your Honor.
Okay.
I tried to get across to Ms. Farkas that the items, and you brought up the one Best Buy, and I do understand what you meant by that being a computer, but the others are items that are still sellable and that are still, they're sunglasses, and they're still just like they were,
Yeah,
and they're still
Mr. Freeland,
current items.
Mr. Freeland, please don't put anything else on the record. We've already gone over this, and I just want to make sure that we're not, Saying anything unnecessary while you take the plea agreement, okay?
Okay.
Officer Doobie, once the, I know there's a surcharge on the cost of supervision, and I think there's like a $2 a month extra charge for something. Like, what is it, what's the bottom line monthly cost of supervision, if you know? Is it like,
It's $40 per month plus 4% surcharge, and then there's the $2 per month DC training and equipment surcharge fee.
okay,
That's on that. So I think it's roughly give or take a little bit about $48.
okay. So what I'll say is, cost of supervision will be waived for any month that the defendant makes a restitution payment of at least $50. I'm just going to round up to 50 to cover it all. Because if you have an extra $50 per month, I'd rather you pay it towards restitution. But if you're not going to pay it towards restitution, then it will be a cost of supervision fee.
Yes, Your Honor.
Okay. So I wrote that off to the side. Court does not accept blanket waiver of cost of supervision. Cost of supervision will be waived for any month defendant makes a restitution payment of at least $50. So.
Excuse me, I'm so sorry.
All right. Mr. Freeland, I think I swore you in already.
Yes.
Yes,
I
ma'am.
interrupted
Thank you.
after that, I apologize.
Sorry. Okay, so in 24 CF 1122, you're charged with one count, the original charge is one count of grand theft, which is a third-degree felony, maximum of 5 years state prison. In 24 CF 1801, again, one count of grand theft, third-degree felony, maximum 5 years state prison. In 24 CF 1802, again, one count of grand theft, maximum 5 years state prison, that's a third-degree felony. And then in 24 CF 2621, it's a charge of, I think, retail theft individually or in concert with others, and it's over $3,000, and that is a second-degree felony, and the maximum penalty is 15 years state prison. Have you had a chance to talk to your lawyer about all of those charges and all 4 of those cases?
Yes, ma'am, I have.
Have you discussed the plea agreement with your lawyer?
Yes, in detail, Your Honor.
All right, great. Did you read and sign the agreement?
Yes, I did.
Okay, and I am looking at page 3 of that agreement, and I see a signature. It says William J. Freeland, and it's dated, well, it has today's date on it. I know
Yes.
there's no way you can see that from where you are, but it is on page 3. Is that, did you sign it on page 3, sir?
Yes, I did.
Okay. Do you understand the rights that you give up when you enter a plea?
Yes, ma'am, I do.
Do you understand you're giving up your right to go to trial in all of these cases?
Yes, ma'am.
Are you entering the plea in each case freely and voluntarily?
Yes, Your Honor.
Is anyone forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what's showing in this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, I am.
I have a score sheet that shows 45.7 total sentence points. Any objections or corrections?
No, Your Honor.
I did review all of the cases. I do find a sufficient factual basis for each one. And State, is there any exculpatory DNA?
No, Your Honor.
All right. Mr. Freeland, if you're not a U.S. citizen, do you understand that the plea could subject you to deportation?
Yes, ma'am.
All right. And it looks like you are pleading to a lesser included offense in 24 CF 1122 of petty theft, and that is a first-degree misdemeanor. The statute number is 812.0142E. And how do you plead to that charge?
Guilty.
Ms.
Contest.
Yeah, there you go.
I accept your plea to the lesser included offense in 24 CF 1122. I find it was freely and voluntarily entered. And in that case, you'll be placed on 1 year of standard probation. You'll be adjudicated guilty of the lesser included offense. 1 year standard probation. All cases and counts will run concurrently. The court is ordering $653 restitution to Sunglass World. And will that address be provided to probation so they know where to send it?
The restitution amounts,
Yes.
I can get over a memo to them.
Okay.
Because there's 4 different victims.
Okay.
And Your Honor, I apologize. Officer Doobie just reminded me that it should technically say 1 year mail-in probation. I had written in just standard probation, obviously,
I will
originally.
cross it out. I know
Thank you.
this is after Mr. Freeland signed it, but this benefits him.
Yes, yes. And I'll make sure that he, understands that, but he
Okay.
has a copy of the
So,
original.
1 year mail-in probation, and $653 in restitution to Sunglass World, less any recuperated cost after Sunglass World.
I'm sorry, Your Honor, that's the phone here, my phone, she's getting it.
You can mute yourself, Mr. Freeland.
Okay.
Okay, well, his phone stopped, so that's fine. Okay, so less any recuperated cost after Sunglass World retrieves the property from Okaloosa County Sheriff's Office. That's if any.
Yes.
Recuperated. I mean, that's up to Sunglass World. It says Sunglass World will retrieve their property from the Sheriff's Office and report any recuperated costs to probation. And then defendant's restitution would be adjusted for any amount that is reported as recouped. $270 in court cost, $150 cost of defense. That includes the application fee. And I've already announced that the court's not accepting a blanket waiver of cost of supervision. This applies across all 4 cases. Cost of supervision would be waived for any month defendant makes a restitution payment of at least $50 to any of the 4 victims in the cases. As to 24 CF 1801, sir, how do you plead to the charge of grand theft?
No contest.
I accept your plea. I find it was freely and voluntarily entered. There's an adjudication of guilt. You're placed on 4 years of, this is mail-in as well?
Yes, Your Honor.
Okay. Mail-in probation. I crossed out the word standard probation, wrote mail-in probation. Concurrent in all cases and counts. $2,299 restitution to Best Buy, less any recuperated costs or recouped costs after Best Buy retrieves the property from Okaloosa County Sheriff's Office. Best Buy will retrieve their property from the Sheriff's Office and report any recouped costs to probation, and then that amount would be deducted off of the restitution total, if any. $515 in court cost, $100, not $150, but $100 public defender fee. And again, the same thing I announced a minute ago about cost of supervision will apply in all cases. In case 24 CF 1802, sir, how do you plead to 1 count of grand theft?
No contest.
I accept your plea. I find it was freely and voluntarily entered. And there's an adjudication of guilt, 4 years of mail-in probation. And again, concurrent with all cases and counts. $2,868 restitution to Lens Crafters, less any recouped cost after Lens Crafters retrieves the property from Okaloosa County Sheriff's Office. They will retrieve their property from the Sheriff's Office and report any recuperated costs to probation, and then that amount would be deducted from the total of restitution due. $515 in court cost, $100 cost of defense, and the same clause with the cost of supervision applies. In 24 CF 2621, sir, it looks like you're pleading to a lesser included offense of grand theft, which is a 3rd-degree felony, and the statute is 812.0142C. Basically, it's the same charge as in case numbers 1801 and 1802. And how do you plead to that lesser included offense?
No contest, Your Honor.
I accept your plea. I find it was freely and voluntarily entered. There's an adjudication of guilt on that lesser included offense of grand theft, a third-degree felony. You're placed on 4 years of mail-in probation. Again, concurrent, all cases and counts. $1,699 restitution to Sunglass Outfitters, which is inside Bass Pro Shop in Destin, I assume.
Yes.
Okay. Less any recuperated cost after Sunglass Outfitters inside Bass Pro Shop retrieves the property from the sheriff's office, and once they get their property, they'll report any recuperated cost to probation, and then that amount would be deducted from the restitution, if any amount is recuperated. $515 court cost, $100 cost of defense, and the same thing about waiver of cost of supervision that I announced earlier applies. Did I leave out anything?
No, Your Honor.
Okay.
Thank you so much for.
Sure. So, sir, you have 30 days to appeal the order of the court in all of these cases. If you cannot afford a lawyer, I'll appoint one for you. And when is the first check-in? And I see Mr. Doobie wants to be heard, so Mr. Doobie?
Yes, I was just going to provide him with the phone number to the probation office that he can call.
So, sir, write this number down. Mr. Doobie, you might need to get up near a microphone. And, sir, you'll need to call this number to check in with probation.
Okay.
This is Officer Doobie here coming up to the podium to give you the number.
Yeah.
There's another issue, fingerprints. That's going to be a condition of probation, and it's going to need to happen soon.
Yes, Your Honor, I believe that he can get fingerprinted where he lives and just provide that within 30 days to probation, to the sheriff's office? Yeah. We have done this before. Oh, yes. Okay, so if, and then he'd provide it to the clerk. So.
Okay, so how does
Mr.
that-
Freeland, there are places you can get fingerprinted. Like I was gonna say the sheriff's office, I think like FedEx does it. So if he gets fingerprinted where he lives, then provides that to the clerk's office here
Okay, so
within 30 days.
I'm writing this on here. So, Mr. Freeland, there's an additional requirement. This is in all cases. So when you go get your fingerprints done, make sure all 4 case numbers are on there. You need to go to your sheriff's office where you live in that county, okay? You need to do that within 30 days and get your fingerprints done. And then you'll have to send that. I don't know if they'll send it for you or if you get it and then you have to send it, but somehow or another it has to get to the clerk of court here in Okaloosa County within 30 days. Okay?
Your Honor, if I happen to be coming to Destin within the 30 days, could I just come there and do it?
Yes, you can, where would he come to the courthouse?
The sheriff's department.
Yeah, he can go to the sheriff's department in Shalimar if he's doing that.
Coming to Destin, he's mailing in. You see what I'm saying?
I do.
Okay, so if you come within 30 days, you need to go to the Okaloosa County Sheriff's Office. And you can get your fingerprints made, and then you need to carry them to the clerk's office and turn them in, make sure the case numbers are on there, okay?
Okay.
All right.
One other thing.
Mr. Freeland, hold on, Mr. Freeland,
Yes.
I can answer any questions you have later. We need to move on. The court has a lot of other cases.
I understand, but you said you were going to bring up in court about.
Yes, so if there's
items.
any property that was taken from Mr. Freeland when he was arrested, anything that's at the sheriff's office, I told him that I would make sure that it's on the record that he can retrieve any property that's his from the sheriff's office.
All right. Yeah,
So,
I mean.
Yeah, so what property got
What-
taken?
what-
I'm not sure. I just wanted to make sure that that was on the record, that if there was any property that was his.
Because Can we approach real fast?
Yeah?
I'm sorry.
Oh, yeah. Okay, hold on just a second. Okay, so either, sir, you need to either state on the record exactly what the property is now, or you can file a written motion describing the property with specificity.
And Mr. Freeland, I would recommend that you don't put anything specific on the record, that if we run into an issue in the future retrieving any property at the sheriff's office, that you let my office know, and we'd file a written motion to that effect. Okay? So you should be able to pick up any property that's yours at the sheriff's office, and if there's any issue, then you contact my office and we go from there.
I will tell you, the sheriff's office is likely going to want an order releasing said property. We're not just
So-
going to release it to property.
What is the, I mean,
And that's,
yeah.
my suggestion, just from experience, would be Ms. Farkas and Mr. Freeland go over the incident report, office report. In
Yes.
there, it'll detail the specific property. Mr. Freeland could say, that's mine. Ms. Farkas can make a note and then give Mr. Strauss and say, hey, are you going to fight or not? If not, we can do an order, inventory item A, this, released, and then an order signed, and then you can go pick it up.
So I can speak with Mr. Freeland about that?
Yes, and if y'all come to an agreement on what the property is and you
Yes.
need an order, I'll sign it, as long as it's agreed upon.
Okay, so Mr. Freeland, I'm going to give you a call, okay? I don't know if you could hear me. Mr. Freeland, I'm going to give you a call. Oh, yeah.
Oh, I'm so sorry. I'm sorry,
That's okay, Mr. Freeland.
I had you on mute, I'm sorry, or we were on mute, I don't think
we
you
were
heard
on-
us.
oh.
So, just go ahead and,
That's okay, so, sorry, we didn't realize we were on mute, Mr. Freeland, so I'm just letting you know that what we're going to do, I'm going to give you a call right now, actually. I'll step out of the courtroom, I'll give you a call, and any specific property that you might have, whatever it is, at the sheriff's office, you and I will discuss it, and we can file an order. I'll speak with the state about you retrieving that at a later time. It's best not to put on the record exactly what the property is. I'm advising you not to do that on the record. So you and I will discuss what that property is, and then we can file an order about that, so that we can handle that, I guess, at a later date. Okay?
Okay.
Okay.
thank you,
Your
sir.
Honor.
Thank you. All right, good luck to you, sir, thank you.
Thank you very much.
All right,
So we're ready for Mr. Tyden G. Pro again, Your Honor, if that's okay.
yes, of course.
We've been over the additional language, and he has signed the agreement. The state is signing the agreement that we've been over.
This is 24 CF 2425.
Actually, it was me that had to sign it, Your Honor. Now I have
Fine.
signed it, and this does not involve state probation, and it does not involve a score sheet, Your Honor. It's misdemeanors. May
All
I
right,
approach?
yes. Mhm. Thank you very much.
Thank you.
All right, so. All right. This is a VOP, violation of probation, in 24 CF 2425. And the misdemeanors are both new laws, right? Oh, there's only one misdemeanor. Nope, there's another one.
There's two, Judge. I had typed 25 CT 2019 new law in, but then I hand wrote in 25 MM 2571 is also a new law case.
Excellent, thank you. So,
And just for the court's awareness, may I? Judge?
Yes, go ahead.
The original misdemeanor VOP in the felony case, 24 CF 2425, was being handled by JCS, and that was an underlying lesser included offense, paraphernalia. Basically, he's now going to be adjudicated guilty on that paraphernalia. He also has, in 25 CT 2019 pending in the county court, a reckless driving, and then 25 MM 2571, that is loitering and prowling.
okay. So there's going to be another term of probation, and it's only going to be on 25 CT 2019? Is that right?
No, Your Honor.
Oh.
I apologize
No.
for hand editing. There is going to be.
Oh, okay, sorry,
There's gonna
followed
be
by
it's
6
gonna be-
months more on the 25 MM 2571. It's a
Right,
consecutive.
I put an asterisk and wrote that in at the bottom, Judge.
My hand was
Sorry.
covering it up. Thank you, sorry about that. Okay,
And we did need the court costs
Okay.
on the misdemeanor cases. I wasn't sure what they were.
For 25 MM 2571, it would be $270, and for 25 CT 2018, it's $368.
270 in 25 MM 2571, and then, and what was the CT court cost? I'm sorry.
$368 for
Three-
reckless driving. 368, yes.
Okay,
Yeah, you can.
okay. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down if you'll just tell me your name.
Titan George Denver Broom.
All right, you can put your hand down. You're here in 25 CF 2425 on allegations that you violated your probation, and there was an affidavit filed on October 27th. It had 5 allegations. Have you had a chance to discuss those allegations with your lawyer?
Yes, Your Honor.
All right, and then in 25 MM 2571, that's one of your new law cases. I'm sorry, Mr. Medina, what's that charge?
Loitering or prowling, Your Honor.
Okay. And is that a first-degree misdemeanor?
I was asking, I apologize, Judge.
Okay.
I think it's second degree.
It's second degree.
Thank you.
Mhm.
So
19, how do you plead to one count of reckless driving?
No contest.
I accept your plea. I find it was freely and voluntarily entered. There will be an adjudication of guilt on all of the underlying charge, well, the underlying charge in the CF case, the violation of probation case, which is paraphernalia. And then there's an adjudication of guilt as charged in your two new law cases, the CT case and the MM case that you just pled to.
Yes, Your Honor.
In accordance with this agreement, probation is revoked and terminated in 24 CF 2425. And it's sentenced to time served, Mr. Medina, on that case?
Yes, it says time served on the VOP case.
Okay, time served on the VOP case, and there are additional costs associated with that. That would be $100 cost of prosecution fee, $150 cost of defense. That includes the application fee. You'll have 6 months to pay those costs and any other costs that were previously assessed in that 24 CF 2425 case before they go to collections. And the same with 25 MM 2571, you have 6 months to pay the monetary obligations that I'm about to announce in
Your
that
Honor,
case. What?
Respectfully, I apologize, and I do, again, greatly apologize by interlineating all this written stuff, but the court costs in the CT case and the MM case, that's all going to be covered by JCS probation. It's just we had to come up with some sort of a due date on the VOP, the existing VOP case, the CF case. So that those would be due within 6 months. The other court costs in the two open cases that are being resolved are all going to be covered under probation.
Oh, it just says there's something drawn here where it says outstanding monetary obligations to collections in 24 CF 2425, and then it says and.
That and 25 MM 2571 related to the line above it when it said and as charged in 25 CT 2019 and 25 MM 2571. That caret did not relate to collections in 24 CF 2425. That's the only case that goes to collections in 6 months.
That's what threw me. Okay,
Sorry, Judge.
so sorry. All right, so only in the CF case do all your outstanding monetary obligations go to collections if you don't pay them off in 6 months.
Okay, and Your Honor, I do have one question.
Sure.
How would I go about, I have a change of address to Escambia County. So would I go to the probation office when I check in and tell them a change of address? I just wanted to go about it the right way.
Yeah, thank you for that. You're going to be checking in.
Actually, he would need is there a card or a flyer for JCS?
That's the QR code.
Is it this one?
Yes.
Okay.
Okay, so you're going to check in online, and then you can tell them where you're going to live.
Okay, thank you so
Yeah.
much.
Sure, I don't have a problem with you. I mean, isn't this phone reporting or online reporting or something like
They
that?
do primarily online reporting. They can require you to report in person, so follow the directions with the QR code, follow that.
Yeah, if they tell you to come in person, though, you got to go report in person, okay?
Okay.
Yeah. So, all right, let's see. Carrying on to 25 CT 2019. There's an adjudication of guilt in all cases here and all of the charges. You're placed on 6 months JCS probation in that CT case, and that will include 24 hours of community service, advanced driver improvement school, and $368 in court costs and a $50 public defender fee. And then in 25 MM 2571, adjudication of guilt, and you're going to be placed on 6 months of probation in that case, but it's going to be consecutive to the 25 CT 2019. So the first 6 months of probation is the CT case. Then when that's over, then you start a 6 month term in the MM case.
Yes, Your Honor.
for a total of 1 year. So no trespassing at 1500 Miracle Strip Parkway, Fort Walton Beach, $270 in court costs, and a $50 PD fee in the misdemeanor MM case. Did I cover everything, Mr. Medina?
Yes, Your Honor, and thank you very much.
Sure, thank you. And sir, you have 30 days to appeal the order of the court. And if you can't afford an attorney, I'll appoint one for you. Good luck, sir.
Thank you, Your Honor. You have a
Thank
wonderful day.
You too. Please check in as soon as, like, within an hour or two of getting out of jail, okay, on that
And so
code.
this, I think we'll take him off December 15
Yes.
misdemeanor day.
Yes, okay. So,
Nathaniel Brown, Judge?
all right, thank you. This is 24 CF 387, Mr. Nathaniel Brown, and he's present, and I believe there is a motion.
Yes, Judge, we have reached a resolution that would moot the need for a hearing on the motion.
Okay.
And there is a revised score sheet. Do you have that? I sent back?
Yes, sir.
I needed to look at that real quick. So you're saying the math was wrong.
Yes, sir. 18 and 18.
May I have a moment with the state?
Sure.
We have a resolution. So.
Okay. Oh, do you need that?
Diane.
Okay.
Thank you. 11/18/25. Yeah, thank you very much. I'm going to use a more
Yeah, I like that.
smaller.
Yes, sir.
Thank you. Okay. No, oh, okay, yes, your paper. I thought you were taking the.
No,
So-
this is my stuff.
I know y'all are working on the agreement. I'm just pointing out Okaloosa County Sheriff's Office has a request for reimbursement for transport from Marion County Jail in the amount of $260.
So that's cost of transportation, so I'll put COT 260, Your Honor?
Correct. It was filed on September 10th,
You understand
2025.
You know, Judge Clark, if
Do you
I wish I
want-
could use it more often, only $260 for a 5-hour drive.
So in other words, you're
Cheaper than
stipulating
Uber.
to that, right?
No, that's okay, yes,
Yeah,
sir.
okay, all right, so we added it, that's fine.
Yeah, time served, I didn't speak that, I guess that's what that is. Yes, sir, thank you. Can I get this for shit back?
No, that goes to the court.
Okay,
You can get it in a few days, it'll be available.
that's okay, that's no worries.
I'm sorry, Judge, I just gotta make sure I have a copy here.
Sure.
May I approach, Your Honor?
Yes, thank you.
Do you have the score sheet?
No, you got it underneath.
Oh, I have it underneath, I'm
Yes,
sorry.
sir.
With a DOP agreement, it's only one page, both sides.
Thank you.
So I was looking for the missing pages. Thank you.
Thank you very much.
So this is the agreement except for the cost of transportation.
Thank you, Ms. Gaines.
Okay, it looks like I am missing, some of the score sheet. I've got 2 pages of it, but I think I'm missing the part I sign.
That's my do with that, sir.
There should be a blank for me to sign.
Yeah,
Yes, sir.
unfortunately, I sent the score sheet back, and so I think these are the missing 2 pages, but should I show it to the state to make sure?
Yeah, if you want to. I mean, they're just forms. You can take a look and make sure the score is on the stuff I have. I just need the part I
Yes, show
signed.
it to the state
Go right ahead.
because I somehow lost possession of it, so we just make sure we got all the pages of the score sheet, so if you don't mind, ma'am. Okay, thank you.
And Mr. Brown, you're here in 24 CF 387 and 24 CF 1219. Thank
Yes,
you.
ma'am.
On allegations that you violated your probation in those cases. The affidavit was filed down in Marion County, I believe, by Officer Maurice Lewis, and it's dated August 19th, 2025. I think we had a contested hearing, if I'm not mistaken. We went over that, but, have you had a chance to talk to your lawyer about those allegations that you violated your probation? Did you discuss?
ma'am.
Okay, yeah. Did you discuss the allegations with Mr. Medina?
Sure did, Ms. Clark.
Okay. And,
Your Honor, I think, may I?
sure.
Just so he's looking on the same thing as the court is looking at, what was the date of the affidavit? I just wanted to make sure.
Yeah, I'm looking at the.
Because they do their paperwork a little different.
I'm looking at the first appearance paperwork, and the affidavit is in there. It was hard to find, but if you.
Right.
Yeah, if you go in there, it's the first appearance paperwork filed on September 2nd. It's docket, I'm looking in the case 1219, ends in those numbers. And it's docket 157, and it's the record of first appearance that was done here. And then the affidavit starts on page 5 of 7.
Does it say, on the left-hand side, complaint/arrest, affidavit, continuation, in the upper left-hand corner? I do. I'm sorry, Judge. but
Yes, that's it. That's the one.
It's, may I just
Yes.
vote so I'm making sure he's seeing the exact same thing? I'm sorry, Judge.
That's okay.
Is it this
That's
thing?
exactly what I'm looking
Okay.
at. Yes,
I wanna
that's the
make sure-
affidavit.
Because it's not the same form that probation up here uses.
It is
So
not.
This is what you're admitting to.
Those are the.
Question or a statement?
Well,
Yes, ma'am. Yes.
Okay, those are the allegations. Have you had a chance to talk to your lawyer about those allegations in this affidavit signed by Officer Maurice Lewis on August 19th, 2025? Have you discussed those allegations with your lawyer?
Yes, ma'am.
Okay. Don't want to know what you've talked about. I just need to know if you've had a conversation. Okay.
Yes,
Have you
ma'am.
discussed this agreement with your lawyer?
Yes, I have.
Okay, did you read and sign the agreement?
I sure did.
I think I'm missing the signature of the state.
Sorry, Judge.
That's okay. There you go.
Thank you.
Sure. And this is, I'm just filling out the score sheet while I'm waiting on that. This is a time served, correct? Is it
Yes,
time
ma'am.
served? Okay.
Yes,
All right. Thank you. Thank you, thank you. All right, so, sir, is this your signature on the back of the agreement?
It sure is, Judge Clark.
Great, thank you. Do you understand that you're giving up your right to have an evidentiary hearing and make the state prove the allegations?
I sure am.
Okay. And is anybody forcing you or threatening you to make you admit the allegations?
Only myself.
Okay. So nobody else is forcing you or
absolutely
threatening?
not. No.
Okay. Has anybody promised you anything other than what's showing on this agreement?
No, ma'am.
Okay. Are you satisfied with the services of your lawyer?
I sure am.
Good. All right. And are you freely and voluntarily admitting the allegations in this August 19th, 2025 affidavit that we've been talking about?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, probation is revoked and terminated. And on each case, or each count, in each case, you are sentenced to time served.
Thank you, Judge Clark.
Oh, thank your lawyer and the state. They're the ones
Thank you,
who
Ms. Dana. Medina,
worked
thank
out
you.
the deal.
Yes,
And let
ma'am.
me announce the costs and fees. In each case, there is a $100 VOP cost of prosecution fee. And in 24-387, there's a $150 cost of defense fee. That includes the $50 application fee. In 24-1219, there's a $100 cost of defense fee. And there's a cost of transportation expense to Okaloosa County Sheriff's Office in the amount of $260. All outstanding monetary obligations will go to collections in 6 months if you don't pay them off. So you've got 6 months to pay them off, then they go to collections. That could affect your driver's license. If you need to get on a payment plan, go see the clerk. They will work with you.
Yes, ma'am. Thank
All
you.
right, and you have 30 days to appeal the order of the court. If you can't afford a lawyer, I will appoint one. And I forgot one critical thing. I have a score sheet, and I know that this has been understandably, it's been a disputed issue. The score sheet shows 36.6 total sentence points. Do you have any objections to this score sheet?
No, that's better than 55.6.
It is. So I'm glad that y'all were able to come to a
ma'am.
score sheet that everybody can agree upon.
Yes,
I will
ma'am.
sign it.
Thank you,
Good
Ms.
luck,
Dana.
sir.
Ms. Medina, very much. Judge Clark, it's a pleasure seeing you.
Thank you, sir. Good luck to you.
Your Honor? Yes. I just want to make sure that revoke and terminate.
Revoke and terminate. Yes,
Thank you.
Have a good day, sir.
yes.
Thank you, Medina.
All right, and
Steve Medina with Russell A. Ledette.
yes. All right, this is case 25, CF 606, and the defendant is present.
And Your Honor, I'm just showing him this score sheet that we already discussed.
Okay.
And, Your Honor, he is signing the agreement that we've been over.
All right, there's also an Okaloosa County Sheriff's Office transportation request.
Yes, Judge, I'm sorry, sir.
Oh, 9191.
$91.91.
Correct.
I'm gonna put COT for cost of transportation. So that would be transportation from Walton County to Okaloosa County Jail, I think, Your Honor?
Let me take a look. I was looking at it last night. It is loading. Taking forever to load.
See that?
Oh, yes, Walton County Jail, it's 81 miles at 45 cents per mile, and plus the cost of the deputy for 2 hours, total of $91.91.
Understand that's being added? All right, he's ready to sign, Your Honor. We
All
have it.
right.
Thank you.
Sure. And we are dealing with the just the regular affidavit a violation of probation that was filed on July 29th, 2025, and it contains 3 allegations.
Excuse me, I'm just need to look at the judge. And I'm just making sure he's looking at what the court's looking at. It's affidavit violation of probation right here.
Yes, July
And
29th.
And Your Honor, I apologize.
Mhm. I think there's a new law, isn't there?
Yeah, and that's something that I had neglected to point out in the version of the, we reached an agreement, and I forgot something I was supposed to point out, but basically he is contesting the first ground, the new arrest. So he wants to just admit, and I thought I'd written it on there, but I am not seeing that I wrote it on there. I intended to. Basically, the admission is to the second and third grounds.
Okay.
The admission is basically to the, or is it just 2 grounds?
There are 3. There is, number 1 is a new arrest in Walton County of possession of paraphernalia.
So he is not entering the admission to that. He is to the positive drug tests. One was for amphetamines and the other one was for meth, and those are grounds 2 and 3. He's
Correct.
admitting those, right? Yes. I'm sorry for that.
Yes.
Failure on my part.
Okay.
Okay. Sorry, Judge.
No problem.
It's been one of those days.
It has been a long day,
Steve, did I sign that?
and we have a
You
long way to
already
go.
did, ma'am.
Okay.
You want to look again?
Yeah, I just can't remember.
I guess you.
Thank you, ma'am. May I approach Judge?
Yes.
The score sheet as well. We do not question the score sheet.
Thank you very much.
Thank you.
All right.
Did I give it to you to copy? Judge,
Yeah, here you
I'm
go.
sorry, I need to let probation copy that.
No problem, there you go.
It has just been one of those logistical days.
Yes.
All right. All right.
Thank you. All right. So, Mr. Leggett, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down if you'll just tell me your name.
My name is Russell Anthony Ledet.
Thank you, sir. In 25 CF 606, it's alleged you have violated your probation. We just mentioned the affidavit filed on July 29th, 2025. Have you had a chance to discuss the allegations in that affidavit with your lawyer?
Yes, ma'am.
All right, have you discussed this plea agreement with your lawyer?
Yes, ma'am, I have.
Did you read and sign the agreement?
Yes, ma'am, I have.
Is that your signature on the back?
Yes, ma'am.
Do you understand that you're giving up your right to have an evidentiary hearing and make the state prove the allegations?
Yes, ma'am.
All right. Is anybody forcing you or threatening you to admit the violations today?
No, ma'am.
Has anybody promised you anything in exchange for getting you to admit the violations?
No, ma'am.
Are you satisfied with the services of your lawyer?
I believe I am, ma'am. Thank you.
All right. And I have a score sheet that shows 37.8 total sentence points, and you said no objections,
No
right?
objection.
All right. Are you freely and voluntarily admitting allegations number 2 and 3 in the affidavit? Those are the 2 positive drug test allegations.
Yes, ma'am.
I accept your admission as to allegation number 2 and 3 in the affidavit. I find it was freely and voluntarily given. And in accordance with your agreement. I believe you were previously adjudicated.
Yes, Your Honor, he was.
Okay. So probation will be revoked and terminated. I do find that Mr. Ledet did violate his probation as to grounds 2 and 3 in the affidavit. And Mr. Ledet will be sentenced to, on each of the counts in 25 CF 606, there are 2 that he pled to, counts 1 and 2. Each of those will be 180 days in the county jail with credit for all time served, including Walton County time on hold for a VOP, and after arrest in 25 MM 426, whatever amount that turns out to be.
And Your Honor, he also, I'm sorry.
No, go ahead.
Interrupt, just for the record, he pointed out to me, he did have some time in on this case when he was originally arrested, so he would get credit for that too.
Of course, whatever the time is, you get that time, but the jail will calculate it. I would not be the one to add it up.
Your Honor, he's just asking, it is concurrent jail sentence between the 2 cases. Between the 2 counts.
Counts, yes. Count 1 and count 2, both 180 days with credit, with all that credit that was just discussed, concurrent, running at the same time, and $100 VOP cost of prosecution fee, $150 cost of defense. That includes the $50 application fee. Cost of transportation to Okaloosa County Sheriff's Office, $91.91. Unpaid monetary obligations will go to collections if they're not paid within 6 months after you are released from jail. Did I leave out anything?
No, Your Honor.
Okay.
He does have a still pending Walton County case. This doesn't do anything to his court obligations over there. He still needs to work with the public defender over there, and so report for court over there as needed.
Right. So, sir, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck, sir.
Yes,
Thank you.
And I apologize.
You're fine. Thank you, sir.